Hi, I'm Pollard. Welcome to my website. Today we're going to talk about workers' compensation mediation, also known as a settlement conference. Now, mediation is basically an assisted negotiation. It's when you and the opposing party, which may include your employer, its workers' comp insurance carrier, and the third-party administrator, hire a neutral third party to sit down with you and to try to negotiate a full and final settlement of your case. So when should you mediate? Well, that really depends on how strong your case is. Now, I don't think there's any such thing as an open and shut workers' comp claim when it comes to compensability. But if you have a strong case, then it makes sense to wait until after you have received an award agreement form and the commission has entered an award order, based either on an agreement between the parties or after a workers' compensation hearing. If you try to negotiate a settlement and participate in mediation too early in that type of case, then you may be leaving tens of thousands of dollars on the table because it may be too soon to know the extent of your injuries, the nature of your disability, and how much your future medical expenses may be. Now, it makes sense to mediate earlier if you have a case that's somewhat questionable on compensability. That's because if you lose on compensability, then you're left with nothing. In most cases, you should get the award agreement, start receiving benefits, both lifetime medical benefits and temporary total disability payments, and then once you've reached maximum medical improvement, ask the other side if they want to mediate. So there's no hard and fast rule, but there are different things you should look for when deciding when to schedule the mediation. Now, the next question is, who will mediate? Virginia is very good with this. The Virginia Workers' Compensation Commission offers mediation services free of charge. So you can choose one of the mediators, and there are several, and many of them are very good, to sit down with you and to help you negotiate a settlement at the mediation conference. You also have the right to choose a private mediator. Now, if you do that, then you'll have to come to some sort of payment arrangement with the defendants, the employer, insurance carrier, and third-party administrator, and decide who's going to pay what. If you choose private mediation, then I recommend agreeing to split the cost of the mediator only if you reach a deal. This provides some incentive to the other side to negotiate fairly. So what happens in a mediation conference? Well, that's a bit more than we can discuss in this video, but to give you an overview, everybody shows up, it starts in the same room, and the mediator lays out the ground rules. And he or she will also ask what type of mediation you want it to be. Either a facilitative approach, where the mediator goes back and forth, trying to help the parties understand the issues and pointing out the strengths and weaknesses of their case, or you can choose an evaluative approach. And with that, the mediator will sit down and tell the parties how much he or she thinks the case is worth. Now, this isn't binding on anybody, but it provides important information to both sides so that they can determine if they're acting fairly or if they're being reasonable in their expectations. I recommend asking for both types of mediation. Start with a facilitative approach, and then if the parties get stalled during negotiation, turn to an evaluative approach so you can try to use that to get more money from the insurance carrier. Now, once you've selected the approach, the parties will break into two different rooms, and the mediator will go back and forth trying to help the parties reach a deal. At the end of the session, which can last anywhere from 3 hours to 10 hours, or even multiple conferences over multiple days, the parties will either reach a deal or they won't. Either way, you meet back in the same room, and if you don't reach a deal, you say goodbye. If you do reach a deal, then you talk about who will draft the settlement documents and move forward from there. It's important that you get any deal put in writing as soon as possible, because under the Workers' Compensation Act, you must get commission approval before a settlement is final. If you have any more questions about workers' compensation mediation, what to expect, and how to prepare, visit my website, cpollardlaw.com, or call me at 804-251-1620 or 757-810-5614.